Hi, I'm Dr. Owen Anderson, and we're continuing a study through my book, The Natural Moral Law, The Good After Modernity. And we're in the introduction right now. We've been looking at some attempts to avoid connecting law and the good. This time we're looking at positivism. And positivism can be really found in the two previous sections as well, that law is the command of an authoritative will, and that law is the power to change behavior. And positivism relies on empiricism. Empiricism says all knowledge is from sense data, and the empiricist is always connecting up things to the particulars. From our senses, we never get to the universal, to the nature of things. And so the empiricist and the positivist never get to the nature of things, and so the positivist legal tradition is in contrast to natural law, where the natural lawyer tries to get to what is the nature of things and base the law on the nature of things. So, for example, a modern example of this would have been H.L.A. Hart, who says that there's nothing gained by claiming that law and the natural law are necessarily connected. Instead, we have some general theories or ideas like justice that guide law, but that natural law itself is unhelpful in giving particular laws. Now, that might be true. That could be a critique of specific natural law traditions, and he may very well be right about that. But the idea of natural law is that the good is based on the nature of a thing. And so what is good for a human is based on the nature of a human. What is good for a horse is based on the nature of a horse. So in order to know what is good for something, you have to know what it is. And to do that, we go beyond our senses. We're using an act of the mind to grasp the nature of a thing, the concept of human, which is a universal. All the particular humans have this nature in common. And from there we get to what the good is for human nature. And therefore, that applies to each of the particulars as well. Each individual human shares that same good as a human. So we want to be able to get to law at that level. And that's not just the particular laws. So that the positivist just says the laws are the ones that are passed by a government. And then H.L.A. Hart is part of a debate after World War II to say, well, but the German nation passed laws, and we seem to think that there would be unjust laws. They were wrong to follow those laws. And so how can we hold persons accountable for following the positive law of Germany without appealing to a natural law? And so he might say, well, we have this idea of justice that we can appeal to. And now we might begin to make a distinction without a difference, and a difference without a distinction between natural law and getting to justice. What is justice? And the universal there. You have to go beyond the particulars and get to law. Now the positivist wants to avoid doing any kind of metaphysics in order to get to law. And there's some, after Hart, new natural law theory would want to say, yeah, we can do natural law without ever doing any metaphysics. Metaphysics is the study of what is real. And when we do metaphysics, we get into all kinds of theories about what is existing and what are natures and what is God. And we don't want to have to do that when we pass laws. In fact, we want to seem to be able to strip law away from any of those things because people disagree about metaphysics and pass laws in a pluralist society where there are many different views about what is real. But can we see that those disagreements are part of what has to be overcome? That response to those disagreements is a continuation of skepticism. We can't really know. We're kind of stuck with these disagreements, and we all think we know, but no one really does. And the response should be, well, what these disagreements have done is they revealed at a more basic level where we don't agree. So we might think of our disagreement up here, but up here presupposes these other levels, which we also don't agree at, and we don't normally talk about them. So our disagreements about what is real are actually grounded in disagreements about how we know. And we have to actually get back to these more basic disagreements in order to make progress up here. That's what it should tell us, and that's what it should encourage us to do. We don't have to accept skepticism as a given, the view that we can't really know, and we just have to pass laws to get along with each other. Instead, we can say, no, we can know, we don't currently agree, and we need to do the work of getting to what is more basic. So legal positivism presupposes empiricism, and we don't agree about empiricism. Knowledge is not from sense data. Knowledge is from reason, forming concepts, judgments, and arguments, and interpreting sense data. And so we can get to the idea of the good. This is not a good argument. This is not a successful argument for avoiding the good in law. But what it has shown us is that the disagreements that we're inheriting need to be thought about presuppositionally so we can make progress and not just continue to perpetuate the same disagreements generation after generation? What is more basic that we haven't yet agreed on? Thanks for joining me. I'll see you next time.